Hello, my name is Adèle Canton. I'm the Chief Judicial Officer Emerita of the National Judicial Institute. It's so nice to be with you here this morning. I am going to start by sharing my screen with you because I have a small PowerPoint that hopefully will help us in the discussion that I will be having with you on teaching judicial skills in Canada. So as I say, I'm the Chief Judicial Officer Emerita of the National Judicial Institute, and we'll be talking to you about teaching judicial skills. I want to start by just explaining how we organize or categorize our education for judges in Canada. We divide it into three dimensions. Now, I'll start by saying I admit that these are somewhat arbitrary, and we debate here, and you can probably debate with me whether certain topics fit within these dimensions. But it is a helpful way to ensure that judges are getting a broad cross-section of the kinds of educations that is helpful to them. Federally appointed judges in Canada are required to do 10 days of education per year, and they're also required to ensure that they have education in all three of these dimensions that you see here. So they are substantive law. I think that's pretty self-explanatory. Skills, and that's what we're going to be talking about this morning. And finally, social context. I'll just briefly tell you what that's about. I can talk a long time about social context. It essentially is understanding the context of the people who come into our court rooms, our settlement conferencing rooms, as litigants, as witnesses, as observers. The Supreme Court of Canada has made it clear to judges in Canada that they need to understand the context of Canadians to ensure fundamental values of equality and true impartiality. Now, whether social context is the right word anymore, I think is open to debate, because we have a better understanding about things like unconscious bias, systemic racism, and so on. So we're actually going through a fairly significant curriculum review at NJI right now, and I suspect one of the issues that will be on the table is whether or not we need to look at that phrase and see if it's the right phrase. I also will say that as part of that curriculum review, we're looking at whether or not we're providing appropriate training in things like judicial wellness. And in fact, that may affect whether or not we have a fourth dimension to our education. So let's move on to skills, which is what I want to talk about today. What is a skill? So the best way for me to describe it to you is to give you examples of the skills training that we do at NJI. Delivering an oral judgment, an important skill for judges, and I'll talk a little bit more about that program in a minute. Communicating in the courtroom, building cultural competence. Those are skills in Canada that judges need to have. As you are likely aware, we are a very diverse country, people coming from all over the world. And so not only do we have the challenges that all judges have about communicating with children, communicating with the elderly, with people whose literacy skills are perhaps in question, but also we must be able to communicate with a very diverse population. The last one I have listed here is deciding cases. You might think, how is that a skill? That's fundamental to the judicial role. It is that for sure, but we look at it also as a skill, and I'll talk a bit about where we're at on that at the end of this. So how do we teach a skill? In one respect, it's a fairly simple model. Most of the teaching at NJI follows an experiential model, which I think is the case with most judicial institutes nowadays. But that model has to be modified somewhat when you're teaching a skill because of the important element of getting the judges to practice the skill. So the model we follow is here. provide some theory about whatever the issue is. And I'll give you an example in our oral judgments course as to what I mean by that. Then you have someone who is good at the skill to model it. You then have the participant practice. There's then an evaluation, a critique from a facilitator, and then have the judge practice it again. So as I say, it's quite a simple model. It does have challenges. The three that I'll identify for you are: first, you need to have a good scenario or hypothetical or example to have the participants practice on. So because we're teaching judges, it will often be hypotheticals or scenarios as to doing something in the courtroom or in the settlement room. And I know from experience that it's very important to take a lot of time planning the hypothetical or scenarios so that in fact it is an effective way of having the judge practice the skill. So what we usually do is I might draft it, or a judge working on the program might draft it, and then workshop it a bit with other judges, other people at the NJI, just to make sure that it fills the bill. Secondly, it's a very labor-intensive way of teaching. Our skills-based programs are usually 30 or 40 judges in the room, and we have them organized and sitting at rounds of 6 or 7 judges. Each one of those tables, or in some cases, we actually move them to breakout rooms, but each one of those groups needs a facilitator. So you need, even for what would be a small program of 30 judges, you're going to need 6 or 7 senior judges as facilitators. So it is labor intensive. The third thing is that it's facility and technologically intensive as well, because you need breakout rooms often. And we do some recording, some video recording of some of our programs. And again, I'll explain a bit when I talk about delivering an oral judgment. So I'm going to assume that in Ireland, judges can deliver some decisions orally. I know there are some jurisdictions where everything has to be in writing. In Canada, a common law jurisdiction, even in Quebec, where it's civil law, judges may deliver their reasons from the bench in an oral decision. And it's important to be able to do that, because otherwise there's a risk that a judge becomes backlogged with a lot of reserve judgments to write. But that said, it's necessary that an oral judgment that is given from the bench is also always as comprehensible, as well-reasoned as if it had been done in writing. So when I talk about oral judgments, I don't mean something where the judge immediately gives a decision after hearing submissions from the parties. Usually for oral judgments, we encourage the judge to adjourn overnight, or maybe sometime next week, not to write it out in full, but certainly to organize his or her thoughts. So that's the kind of work I'm talking about here. So we have 2 ways we teach this skill to judges. All judges must attend new judges school, and they get about a day's worth of education there on doing good oral judgments. And then we have a standalone 3-day course, which goes much more into depth. So looking first at what the structure of the program looks like, in either case, we provide the theory. So what's the theory in oral judgment training? We have an English professor talk about a good organizational structure, and we encourage judges to have a point-first structure where they start their oral judgment with what the issue is. The decision I must make today is to determine whether or not Johnny may now start having overnight visits with his grandparents. There you go. We also teach theory on the legal requirements. Our Supreme Court has set out some requirements that judges must follow in terms of ensuring that any decision they make has sufficient reasons for appropriate appellate review. And so we give that to the judges. And then we have a communications expert slash actor talk to the judges about judicial comportment in the courtroom. And, specifically during the delivery of oral judgments, no mumbling into papers or computers. Look at the parties. If you are talking to them directly as part of your decision, look them in the eye, and so on. Then we have the judges draft a hypothetical oral judgment. It's videotaped during that process. There's a facilitator, a judge facilitator during that videotaping, and then it's reviewed by the whole group with the rest of the judges. So the process is in a breakout room. The judges would come in one after another, deliver, in the case of new judges school, a 7-minute oral judgment. It's videotaped, and there is the judge facilitator there. You'd have a conversation with the judge one-on-one after the videotaping is completed. Then after all the judges have individually videotaped them, the whole group of 6 plus the facilitator get together and discuss each other's work. It's for in new judges schools, it's a bit humbling for the judges, but it also always receives very good evaluations. Now for the 3-day course, it's just more in-depth. We divide up oral judgments into pieces. We start with the theory, modeling, and practicing the introduction, that first paragraph, which is so important. And then we will do theory, modeling, and practicing certain segments. For example, how to do a oral reasoned judgment when there is a credibility issue in a case. So that's oral judgments. I'll just give you a little bit of a insight into our communicating in the courtroom skill. In this case, there's a lot of times when the judges are expected to practice spontaneously their conduct in the courtroom in terms of communication. So a judge would not see what you see on the screen here. A judge would be told that he is sitting on a sexual assault case. The complainant is on the stand. The plaintiff is being cross-examined by defense counsel, and defense counsel is likely to attempt to stray into prohibited areas of cross-examination. The actors, and we use judges as actors, volunteer lawyers as actors, sometimes paid actors, depending on the program. They would see this. It would explain what the scenario is. And then the specific actor in this case would be a defense counsel. And so the defense counsel is given some direction in terms of what we'd like him or her to do. And it is to be somewhat persistent in going into impermissible lines of questioning about rape myths and stereotypes. So the judge's job here is, first of all, to know when to intervene, and then how to intervene. So how to communicate with the defense counsel. It may be, if the judge hasn't intervened quickly enough, that we have a complainant who's become upset or emotional because there have been questions asked of the complainant that are upsetting. And so how do you communicate with a vulnerable person in that situation? So that's another skill that we teach in our courses. And this takes me to my last course I want to talk about, and that's deciding cases. I said at the beginning that this may seem as such a fundamental part of the judicial role that it's not a skill in the same sense as how to communicate to a upset witness. We treat it as such because the model that we'd like to follow is the same. A little background. We had a course called Good Judgment that we offered that was intended to talk about how to decide cases, how to deal with precedent, what to do if there is no precedent and it's a novel point of law or fact or a novel situation. What do you do about incorporating other legal orders? So in Canada, if it's a common law judge, civil law principles, indigenous law principles, and so on. So some really important fundamental concepts. The program we had designed did all that, but in a very academic, theoretical way. It was a very interesting course, but interesting to a very narrow segment of the judges, not the judges in their first years as judges, where they're learning how to do the job. So as a result, attendance gradually was reduced, and we stopped the program and decided to work on a remodeling of the program, incorporate the kind of theory I've talked to you about teaching skills, and we're in the process of doing that now. Our planning will happen this year, and likely the first course will be delivered next year. So that's it. I want to thank you for your attention. And I just want to say, you'll see up in the corner of this slide, IOJT NJI 2022. NJI is hosting the 2022 conference of the International Organization of Judicial Trainers. It'll be in Ottawa, November 2022. We fully expect that we will be able to put on the conference as an in-person conference, and we would invite people who are interested to attend from your group. Go to iojt2022.org. I'm just working on the website now, so it's not particularly well populated, but it will be in the next few weeks. So with that, I'm going to stop sharing, and I'm going to say thank you and looking forward to the discussion.